Hello, I'm so glad to be here. I'm Jessica Silbey. I'm a professor of law in the School of Law, and I'm going to talk to you about something very different. I'm going to talk to you about intellectual property. The US Constitution grants Congress the power to promote progress of science and the useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. Historically, what this language has meant is that Congress passes laws granting copyrights and patents to authors and inventors to recuperate the investment in their work. This has been a story that is an economic story. That is, the theory behind IP is that IP are chits to trade, to exchange for money and revenue in order to produce more. And that story of more money, more IP has been the way that progress has been defined under our intellectual property system. More accumulation, more aggregation, and it's without regard to distributional equity or other social values. But that's changing, and that's what my research has been showing through both an empirical and legal evaluation of both cases and ethnographic studies. The digital age is challenging this idea of what progress means. So what I've been learning by studying intellectual property disputes and interviewing authors and inventors and their business partners, for example, is that the economic story is being depressed and the stories about other values are being elevated. Values about equality, anti-discrimination, privacy, self-determination, distributional justice, for example, fair wages for hard work, and institutional resiliency. These other values are rarely part of the conversation around intellectual property for the past 150 years, but they are now, and that's strange to lawyers. It's strange to law professors as well, and that's what I'm studying. So let me give you an example. This is Naruto. She's a macaque monkey in Indonesia, and she took this picture of herself. David Slater is the photographer who set up the camera, and he invited the monkeys to come. The monkeys came and took many such selfies. He's there in the bottom. And when he published these photos and he licensed them for money, PETA, the Protection for the Ethical Treatment of Animals, sued him for copyright infringement. Now, no one's laughing, but it was funny at first until it became a lot of money, a lot of expense for both parties to litigate this on the question of who's an author under US copyright law. They spent, both parties, a lot of money to argue about the dignity of authorship under US copyright law. PETA sued to talk about authorship as an exertion of will in the world. Not that monkeys are humans, but that monkeys should have certain basic rights like humans. Now, children can be copyright authors, corporations can be copyright authors. It is not clear why monkeys cannot be copyright authors either. And what this debate became is not really about copyright law, but about how the planet's resources are growing scarce and where empathy and cooperation are necessary to survive. Animal rights became part of the copyright conversation. Second example is Cindy Lee Garcia. She performed a small part in a film she was told was called Desert Warriors, but then when it went back online on YouTube and was seen millions of times, her voice was dubbed over and it became a hateful anti-Muslim screed. She tried to get it taken down. YouTube rejected that because she was not the author and she was not the owner. The filmmaker was outside the US jurisdiction. This went up to the Court of Appeals of the Ninth Circuit twice, trying to get this case taken down. This was about personal security. Her body was in jeopardy. She was getting death threats, but she was not the author. She was only an actor and she had no control over this, and Google won this lawsuit. But this isn't really about copyright. This is about privacy. It's about defamation. It's about misrepresentation and misinformation. And it's about the exacerbation of privacy and invasion by platforms like YouTube or Google or Facebook, whose policies prioritize efficiency and growth over other values. So what is progress today in these IP cases? They're about privacy and equality, about scarce resources, institutional resiliency, and about how human flourishing is going to go forward in the internet age. I look forward to hearing more of your talks.